right, we are on record now, and you may call the next file, Mr. Madama.
Thank you, Your Honor. This is People versus Randall Allen Grimless, file 24-046680-FC. Date and time set for sentencing. The defendant appears in person from the Allegheny County Jail with his attorney, Mr. Silsky.
All right, and Mr. Silsky, you're present and your client has also been brought into court, correct?
Yes, Your Honor, he's here.
All right, and let's take care of the SIR completion first. Court has received the people sentencing memorandum as well as defendant sentencing memorandum, and that had the details set out. So we'll go over the offense variables. OB3 was scored at 50, I believe. Both attorneys are in agreement that that should be 25. Is that correct?
That is correct.
Yes, Your Honor, that's correct.
Right, and then in regard to OB5, so that will, OB3 will be made 25 points then. OB5 is currently scored at 15. Is that correct with your calculation, Mr. Madama?
Yes, Your Honor.
As well as yours, Mr. Silsky?
Yes, Your Honor.
All right, then we'll move to OB6. That's scored currently at 10. Mr. Madama, you were making a request for 25 points. Mr. Silsky is opposed to that. You may go ahead with your request, Mr. Madama.
Thank you, Your Honor. Offense variable 6 should be scored at 25 points. 10 points as currently in the PSI is more appropriate if the jury had found the defendant guilty of manslaughter. The sentencing guidelines manual essentially mirrors 10 points for a manslaughter conviction. 25 points is essentially mirrored in the second-degree murder conviction that was handed down by the jury. So offense variable 6 should certainly be 25 points.
All right, Mr. Silsky, what's your position in regard to that?
Your Honor, our position is that the agent correctly scored offense variable 6 at 10 points.
All right, so for 10 points, it would be based on there was gross negligence amounting to an unreasonable amounting to an unreasonable amount or unreasonable disregard for life. 25 points reads as follows: the offender had unpremeditated intent to kill, had the intent to do great bodily harm, or created a very high risk of death or great bodily harm, knowing that death or great bodily harm was a probable result. The court is finding that 25 points is appropriate for the creating a very high risk of death or great bodily harm, knowing that death or great bodily harm was the probable result. We had testimony that defendant was trained in CPR, and the court is finding that based on his behavior, on the defendant's behavior, then he did create that high risk of death or great bodily harm, and he knew that that was a probable result or a likely result. And so the court is finding that for OB6, that 25 points is more appropriate, so 25 points will be scored there.
Thank you.
So now we may move to OB10. You are asking for 5 points there, Mr. Madama. You may go ahead with that argument.
Thank you. Offense variable 10 is properly scored at 5 points when the offender exploited the victim by his or her difference in size or strength, or both, or exploited a victim who was intoxicated under the influence of drugs, asleep, or unconscious. This court had heard evidence presented at trial in the manner that multiple times the defendant said the victim did not fight back or move because of the differences between his size and her size, and because she was intoxicated and had taken her medication. So offense variable 10 is properly scored at 5 points.
All right, and Mr. Silsky, what's your position in regard to OB10?
Again, Your Honor, our position is that the writer of the PSI report correctly scored it at 0 points.
The court is agreeing with Mr. Madama at this time because of the size difference. There was testimony that there was 100 pounds of size difference between the victim as well as the defendant. So that size difference, and there's also plenty of testimony throughout the trial that the victim was also intoxicated. Right, so OB10 will be scored at 5 points. And the only other thing that was scored was in regard to OB19. I believe both attorneys agree that OB19 should be scored at 0 points. Is that correct?
That's correct.
Yes, Your Honor, that's correct.
Right, thank you. So then the total points is for 70 points on the offense variable, which keeps it in the same range, the same point level, and the guideline minimum range does not get changed either. So the guideline minimum range is 180 months to 600 months. That's in regard to the minimum guideline range. All right, did you have anything that you wanted to add at all to the PSI, Mr. Meadow?
No other additions to the PSI, Your Honor.
Anything else in regard to the PSI, Mr. Silsky?
Your Honor, I believe that we should briefly discuss the guideline scoring for the count 2 for the larceny over $1,000.
Yes, we can go ahead with that.
Your Honor, on that, once again, offense variable 19 was scored at 10 points, and I believe the correct score would be 0 there. The offense variable total would be 5 points, and the PRV level would not change, but the guideline range for C1 is 0 to 18 months.
All right, what's your position in regard to that, Mr. Meadow?
I concur with that, Your Honor. Thank you.
The court also concurs with that, so the guideline minimum range will be 0 to 18, and the OB-19 will be scored at 0 points. All right, thank you. So, Mr. Meadow, do you have anybody here who wishes to make a statement?
I do, Your Honor. Lisa Vanderyacht is the representative of the victim, Donna Heimer's daughter, would like to address it.
All right, you may come forward. Come right up to the corner. There's a microphone on the very end of that corner. And so stand right by there, and go ahead and state your full name first of all.
Lisa Marie Gertrude Vanderyacht.
And go ahead and spell your last name.
Vanderyacht.
And what's your relationship to the victim here?
She's my mother.
Thank you. You may go ahead with your statement. And just keep your voice up because it all is being recorded. Thank you.
Your Honor, my mother was murdered by Randy Grinvis. He was not a stranger, he was family. We let him in. We trusted him. For 20 years, he was one of us. And in return, he stole my mother. I want the court to understand something about who she was to him. She was the only thing keeping him on the straight and narrow. Without her, he had no structure. He was unable or unwilling to have self-discipline on his own. They were in a race to the bottom long before she died. And now that she's gone, he has nothing. No structure, no discipline, no one to hold him accountable. What does he have to offer society? I also want the court to understand that I gave him the blueprint. My mother and I had a rocky past. She was difficult. I know that. But I told him how to build a respectful relationship with her. I gave him the answers. I showed him what the work looked like. And instead of putting in that work, he ignored it. He had the answers. He knew what to do, and he decided it wasn't worth it. He chose every day not to do the work, and then one day he snapped and took her life. Let me be clear about what he meant by snap. In his own words, it was a day just like any other. Yeah, they were fighting, that was normal. But she wasn't being extra mean. Nothing about that day was different. He just snapped. An ordinary fight, and he decided to end her life. I want the court to remember something else he said. After he took her life, he said that if he had won in Vegas, he would have kept going. He didn't stop because he was sorry. He stopped because he ran out of money. Doesn't sound like a man with a guilty conscience. It sounds like a man with a hungry stomach. It's not a man who made a mistake. It's a man who had the tools, had the instruction, had the support, and chose to let it rock. He knew what to do. He knew how to be better. And he decided she wasn't worth it. It's not somebody who belongs in society. He broke our trust. He stole my mother. She never got to meet her great-grandkids. She never got to pay off her own house. She never got to grow old. And I had to go through everything that came after. The grief, the confusion, the paperwork, the questions I'll never get to ask her, without the one person I could always turn to. He stole that from me. And why? Because she was mean to him? Because his feelings were hurt? If somebody's treating you badly, you leave. You don't stay. You don't take their life. He had
We're stepping into a high-stakes sentencing hearing where every word, every number, and every decision could mean decades of someone's life. Stay sharp, because what unfolds here isn't just legal procedure, it's the final chapter of a tragic story.
Perfectly fine house right across the street, but he wanted hers, and she wanted safety. And because of his actions, neither of them got what they wanted. I lost 2 people that day. My mother and the man I thought I knew for 20 years. I didn't realize how complicated losing somebody in that way would feel. I trusted him. We all trusted him. And he took the one thing you can never replace. Your mother. You only get one. She's gone now. Gone because he didn't want to do the work. I trusted him with her life, and now I have to live with that for the rest of mine. The best I can hope for at this point is the knowledge that he won't be able to do it to anyone else.
All right,
Thank
thank
you.
you for sharing that. It's very meaningful. Thank you. Or do you have anyone else here to make statements?
No, Your Honor, I do have elocution.
You may go ahead with that.
Thank you. Your Honor, I couldn't say it much better than Lisa did. I expect that you'll probably hear that he walked into that Las Vegas police station because he just couldn't take it anymore and had that guilty conscience. That's not what the evidence bears out. He fled to Vegas, he extended his stay at his hotel. He even outright said to Ottawa County Sheriff's Department investigators, I would have kept running if I wouldn't have lost that money. If I would have hit when I gambled, I would have kept running. He walked into that police station not because of a guilty conscience, but because out of necessity. He was homeless in Las Vegas, has had nothing, no other choices. We can't look past the way that he killed Donna either. This was not, he says he snapped. He said over and over, I snapped. This was not a snap. 2 of the people's witnesses said this would have taken minutes, but even by the defendant's own expert, she said it would have taken at least 40 seconds. At trial in this matter, if you remember, I held up my phone and played 40 seconds and how long that was. He had 40 seconds to change his mind, and instead he continued pressing down on her. So that also cannot be overlooked. I was a bit surprised by the recommendation in the PSI, given the guidelines that he has, even with that 10-year gap. The way he did it, what he did afterwards, Your Honor, he has earned himself a sentence at or near the very top of those guidelines. Thank you.
All right, thank you. All right, and Mr. Silsky, do you have anything else, Mr. Meadow?
I do not, Your
All
Honor.
right, thank you. So, Mr. Silsky, do you have any corrections or anything in regard to the PSI yet?
None other than the questions we had on the scoring of the offense variables, Your Honor.
All right, so those have been dealt with?
Yes.
And what would you like to state on your client's behalf?
Thank you, Your Honor. I think unsurprisingly, I'm saying that he was motivated by grief at the time when he turned himself in to the Las Vegas Metropolitan Police Department, when there was no warrant outstanding, when the investigation wasn't moving, as far as we know. All of the information that he provided was the glue for the timeline that the prosecutor presented to the jury. Going to the casino, going to Chicago, going to Vegas. The police didn't have any of that information. They only started looking for that once they had the report from the Las Vegas interview with the detective out there, in which Mr. Grinwas fully accounted for what had happened. Was he desperate at that point because of having no money? Undoubtedly. But he didn't have to turn himself in to the police in order to find a place to stay. They have homeless shelters in Las Vegas. He didn't have to confess in order to get a meal. In fact, there's no indication that when he was at the police department that he was asking for food or anything, other than the opportunity to talk to the police. So I say that that shows he was motivated primarily by his grief. It took him a while to realize it, to realize the magnitude. I don't think that's unusual. So we would ask the court to consider minimum sentence near the lower end of the guideline range. Thank you.
All right, thank you. Okay, so, Mr. Grinwis, I'm going to ask you to state your full name, please.
Randall Allen Grinwis.
And have you had an opportunity to read through the pre-sentence investigation report?
Yes, ma'am.
And do you have any corrections to this report, the pre-sentence investigation report?
No.
And is there anything you want to say before sentence?
No, ma'am.
Right, thank you. Right, so the court has read through the pre-sentence investigation report. This is a very sad situation and sad case. This was an incident that could have been totally avoidable. You had options. You could have left the place where you were living with her. You had other options, but you chose to do a very drastic and very evil option. So in regard to sentence here, the court is going to sentence you now in regard to the two counts, the one count for homicide second degree, or murder second degree, and then the count two for larceny of $1,000 or more. In regard to the count one for the homicide, you must pay restitution in a total amount of $5,445. $3,645 is for funeral expenses to Lisa Vanderwall. And $1,800 is for Randy Barton because you took his money. You must pay a state cost fee and a crime victim assessment fee. The court is going to waive the other costs and fines and your attorney fee. In regard to count one, the sentencing memorandum had a recommendation from the people, and it also had a request from the defense. And of course, they're at opposite ends. The prosecutor is asking for the high end, the defendant is asking for the low end. So the court is going to do the following. In regard to count one, the court is going to go to the middle of the guideline range. And that is for 32.5 years. In the Michigan Department of Corrections on the minimum end. You are sentenced to the Michigan Department of Corrections for a period of not less than 32.5 years to a maximum of 90 years. That in months is for 390 months on the minimum end to 1,080 months on the maximum. In regard to the count two for larceny, for the habitual fourth there, the court is sentencing you there for 365 days. The guideline range now is 0 to 18 months. The sentence is for 365 days on the count two with credit for 365 days already served. And the guideline range, or the PSI calculates that you have 805 days of credit for jail time. So in regard to the count one, we have 805 days of credit. This is the final sentence of the court. So you will get some paperwork now in regard to your ability to appeal to the Court of Appeals, both your conviction and your sentence. If you wish to ask for a court-appointed attorney, you may do so. One will be appointed for you at public expense. You have 42 days to fill out the form and turn that in if you want an attorney for an appeal. Do you have any questions at all?
No.
Right, good luck to you. We're adjourned. Defendant's remanded. Thank you.
Thank you, Your Honor.
Now here's where things get technical, but crucial. These offence variables are essentially a scoring system. Each number directly impacts how long the defendant could spend behind bars. Even a small change, like from 10 to 25 points, can add years, sometimes decades. 040 to 339.